I call the member for Maitland.
Thank you, Mr Deputy Speaker. I rise to speak on the Civil Liability Amendment Organisational Child Abuse Liability Bill 2018. We on this side of the House do not oppose this amendment, and broadly this bill will most importantly create a duty on organisations to prevent child abuse and ensure that organisations must prove that they took reasonable steps to prevent the abuse. The bill will also make an organisation vicariously liable for child abuse committed by employees and persons akin to employees. And thirdly, the bill enables survivors to identify a proper defendant to sue in the case of an unincorporated association by allowing proceedings to be commenced against the unincorporated organisation or association in its name, and allows the organisation to appoint a proper defendant. If a proper defendant is not appointed within 120 days, the court may appoint a proper defendant, which are the trustees of an associated trust of the organisation. This third component is retrospective and extends to proceedings commenced before the commencement of legislation. At the outset of this discussion, can I say that this amendment is overdue and it is also necessary. I know that the member for Liverpool and Shadow Attorney General tried to bring this bill and these issues to the attention of this place in November last year in a private member's bill, 10 months before the member for Cronulla introduced the current amendment. The Attorney General has tried to portray his government as being among the leaders by being the first to opt into the National Redress Scheme for survivors of institutional child sexual abuse. Yet here we are today, virtually as the member for Liverpool intuitively predicted, yes, suggesting nearly 12 months ago in November 2017 that it would take the government another 12 months to finally debate the issues in this bill. And what kind of a message does that send to the survivors of sexual assault in this state? The Liberal National Government is too busy putting together their strategies, their policies, but this is one that they have lagged behind on. I'd like to take a moment to acknowledge the victims as well as the courage and tenacity of the survivors, because even though a light has finally been focused on the truth of their individual injustices, it alone cannot remove the pain and suffering that they live with every single day. As difficult as the past 6 years have been for Australia since the then Prime Minister Julia Gillard announced the Royal Commission into institutional responses to child sexual abuse, we should all be thankful that survivors have finally had an opportunity to speak, and that their nation has finally listened to the unthinkable, and that governance is now finally trying to act and to prevent it happening again. Next Monday, the Prime Minister will make a national apology to victims and survivors of institutional child sexual abuse, but yet again, this is not the end of this process, yet another step in the redress of this stain on our nation's history. The amendment before us, as I mentioned earlier, is in my mind a late redress on this specific situation, but hopefully underscores that we are heading in a new and much more enlightened direction for the future of the care of children in our state and in our nation. The first part of the amendment establishes clear ground rules for all organisations that exercise care, supervision or authority over children. They will have to act to prevent child abuse being perpetrated by individuals associated with the organisation. It also rightly makes the organisation prove that it has taken those reasonable steps to prevent any abuse. And can I also suggest that this place, we have a special duty to closely monitor and scrutinise child protection legislation wherever it is, to ensure that we take our role as legislators and our oversight role seriously and act on it. The second component of the amendment is brave and bold, but again highly necessary to tackle the question of vicarious liability for organisations. There has been a long-standing need to establish clear and simple rules about when an institution is liable for the intentional criminal conduct of someone else. The Attorney argues that the bill levels the flat playing field to ensure that all survivors have access to a civil remedy through vicarious liability and provides a deterrent to all institutions where appropriate. I have to agree with a comment made previously in this place by the member for Liverpool and Shadow Attorney General that it's a reasonable proposition to see that the community would expect an organisation to do all it reasonably can to prevent child abuse. If it does not do all it reasonably can, it should be held civilly liable. The Royal Commission commented that the significant financial consequences that may flow if the community standard is not met create powerful incentives to institutions and their insurers to take steps to ensure that abuse is prevented. Changes to the duties of institutions do more than provide an additional or more certain avenue for victims of abuse to seek compensation after institutional child sexual abuse has occurred, and changes to the duties of institutions are critical measures for preventing institutional child sexual abuse occurring in the first place. The third part of this amendment will also finally provide clarity for victims by giving them a proper defendant to sue. And my hope is that this finally ends the hiding behind an unincorporated organisation and gives power to the court to appoint a proper defendant if necessary. I note the comment of the attorney in this place recently when he said it's important for survivors that responsibility be squarely attributed to the organisation in which they were abused. This amendment represents three significant and, as I've suggested, overdue steps to assist survivors of organisational child abuse. And I'd just like to spend a bit of time in this chamber to really note my intense admiration for everyone in our community who has experienced child sexual abuse in an institutional setting. I've spoken about this before in this place, Mr Deputy Speaker, and that my role when I was at the Department of Immigration and Multicultural Affairs many years ago of reading so many of these stories and hearing about them in preparation for a Royal Commission that was then being undertaken by the West Australian Government. And to hear the names of those institutions even today, for someone who read merely those stories, didn't experience it for myself, but who read those stories of those children, strikes horror into my heart. To think about the things that little children were experiencing on a daily basis by the institutions that we as a community trusted, and their parents, sometimes without their consent, had entrusted their children to, is completely chilling and awful. And the devastation that was wrought upon those children in their adult life was completely incomprehensible to those who did not experience it. I can remember very vividly stories of people who had become lifetime addicts of alcohol or other drugs, who had stories that when they finally got to see someone in rehabilitation for their substance abuse were told that it was fantastic, that they could not have actually experienced the abuse that they had, that no one would have put them on a boat from the other side of the world to bring them out to Australia and dump them in a remote community to build by hand magnificent buildings for a church. They were just told that everything that they had experienced in their lives was wrong and that it was never going to be possible, and it would never have been possible. So time and time again, their stories of abuse at every level were denied by governments, were denied by anyone who had any opportunity to help them. And these changes in this bill are so important, and it's why it's so frustrating to those of us who care about stopping the sexual assault and sexual abuse of people in our community, and so galling that when the opposition comes a year ago with a bill which would have addressed this issue, it becomes a political debate with the government and not actually something that is enacted. And so I just think of those people who have waited an extra year for the government to act in this way, and the disgust that I feel that this government has not done that before now and has chosen to make this a political issue. So I will end my contribution there, Mr Temporary Speaker, and I will urge everyone in this place to support this bill as they should have done a year ago. Thank you.
Mr Speaker.
The question is that this bill